L-1A or L-1B, which to choose? Believe me, there's more than just a one-letter difference between these two visa options. And even though they're both part of the L1 category, there's a world of difference between the requirements, the criteria, and the potential pitfalls of an L-1A and an L-1B. So in today's video, I'm going to go through all of this. What are the differences between the L-1A, L-1B? Which type of employee or applicant is each one intended for? What are the costs? And what are the pitfalls that you need to watch out for so that you know, regardless of which one you choose, you know that will be a successful and appropriate choice for you and or your business partners or employees. By the end of this video, you'll know which option is best for you, and you'll realize it's more than just a label or a one-letter difference between the two names. Hey everybody, my name's Charles Raether. I'm the managing partner of AmLaw Group, based in the Miami, Florida area, where for nearly 20 years, we've been assisting entrepreneurs, business people, startup founders, develop, grow their business presence in the United States. If you have any questions about L-1A or L-1B or any related items, feel free to leave those in the comments section below. So, to give a little context to the whole discussion, let's just clarify what's an L-1A and L-1B. So the L-1 visa in general is intended for people who have worked at least 1 year at an affiliated company overseas, and affiliated means the controlling shareholders of the overseas company are the same as the controlling shareholders of the US company. So you have an overseas company where the applicant has worked for at least 1 year in the prior 3 years, and then now that applicant is coming to the US to work for an affiliated company and perform work here either in the capacity as an L-1A or an L-1B. So L-1A is for executives and managers. So think of that as, those are the bosses, right? Whether it's managing a large component of the company or being an executive, generally the CEO of the company and overseeing everything. You don't necessarily have to have the exact same role overseas as you do in the US. For example, you could be maybe the CFO overseas, you're in charge of all the financial and tax related issues as a CFO, but when you're moving to the US, you might be the general director, the CEO, for example. But as long as they're both managerial or executive positions, that would qualify. That's an L-1A. L-1B, which generally is not as common in our practice and overall, I think. L-1B is for specialized knowledge workers. Again, same requirements apply. You have to work at least 1 year at the affiliate overseas before coming here. But these aren't managers per se. These are people that have specialized knowledge. They know certain skills. Maybe it's in-house proprietary software or in-house equipment, or it could even be in-house knowledge and systems and know-how, say like in a consulting company or something like that. So somebody that has a very in-depth knowledge of, certain industry or your certain, consulting work that you do, and it's not really feasible for you to go out in the open market and find people with that same knowledge or skills. Again, an L-1B is not necessarily for just experienced specialists. That alone is not satisfactory. It's more for people with a focus on the word specialized knowledge, right? So people that possess unique skills and knowledge that generally were developed within the company, and then those skills or knowledge would be relevant and required here at the US operations. And here where it's very important is to look at the actual job duties of the applicant as opposed to just their title. Because in some cases, somebody might have a title like, maybe technical manager or head of technology. But in fact, their job role is more of a specialized knowledge worker. So it's very important to look at the actual job duties, not just the job title, because that's what USCIS is going to look at. What was the experience and the job activities of the applicant prior to coming to the US? And then what will be those activities and job duties in the US after moving here? Another factor that might play a role in your choice between L-1B is what are the long-term goals that you have or this applicant has. If you or the applicant is looking to acquire eventually a green card, the L-1A is generally a little bit easier to convert to a green card. And why do I say that? Well, in either scenario, L-1A or L-1B, you could always go the labor PERM route, right? You could apply for an EB-2 or an EB-3, depending on your level of education, and that could serve as a means of getting a green card. So again, EB-2, EB-3, it's an employment offer, and through that employment offer, you're able to get a green card. And it doesn't matter if it's an L-1A or L-1B, but there are restrictions. For example, let's say you are the owner of the foreign company and you're also the owner of the US company. You could not get a green card through a labor perm, because if you or any close relatives have ownership in the U.S. company that's making the job offer, you're not eligible to file for an EB-2 or EB-3. So in that scenario, you definitely, though, despite having ownership of both entities, you certainly could apply for an EB-1C. And I would say that's the most that's the most commonly chosen option among our clients who are founders or owners of the U.S. and the foreign company, and they want to eventually stay here in the U.S. So they might come initially on the L-1A, work here a year or two, develop operations, grow the business to the necessary size, and then they would file for the EB-1C. With the EB-1C, it doesn't matter if you're an owner of the company or not. And so in that regard, having an L-1A is easier to convert over to a green card through an EB-1C. An L-1B, we've just never had it, and to be honest, I don't think it's really doable. I don't think it's doable to convert from an L-1B to an EB-1C, just because the EB-1C is for managers, directors, and similarly placed people. If you're an L-1B, as a technical person, as a specialized knowledge person, you're not necessarily a manager or director, and therefore you wouldn't qualify for an EB-1C. You could qualify for the EB-2 or EB-3 through a labor perm, but where doable or where possible, we certainly recommend to our clients to choose the route of the EB-1C, because it's much faster. You get premium processing within 45 business days, and you can get through the whole process relatively quickly. With a labor perm, if you have to go that route, as of the time of this filming in the summer of 2026, you're probably looking at a minimum of 3 years from the time you start until when you're able to either go to the embassy or adjust your status. So it is taking much longer through the perm route. So to summarize, L-1A, L-1B both have their benefits. L-1A generally more common for founders, owners, and certainly managers or executives. L-1B generally more prevalent and usable for maybe employees that you have that you want to bring over temporarily. Both need qualified employment overseas and having a minimum of 1 year employment overseas for that foreign affiliate. L-1A better aligns with converting over to a green card, whereas the L-1B generally is a little bit more limited and takes more time if you go the route of the EB-2 or the EB-3. The important thing is to plan your documents in advance and develop a strategy before you start the process. Because if you make a pivot one way or the other midstream, it could be very difficult, if not impossible, to bring over employees or even convert your status to an EB-1C or similar one if planning wasn't done properly at the outset. If you're considering choosing between an L-1A or an L-1B or looking at other options, please reach out to us using the contact information below, either the links or via email or phone, to set up a one-on-one appointment with somebody from my staff or even myself to discuss your particular needs and how we can assist.